Hello everyone and welcome to part 3 of the property offences tutorials. So in this tutorial it's going to be a much shorter one because we're going to be looking at the offence of robbery. So robbery we will find under section 8 of the Theft Act 1968. Essentially robbery is a culmination of offences put together, if you like. Remember that theft underpins all property offences that we've looked at. So burglary encompasses theft, and 2, robbery encompasses theft as well. Robbery is essentially theft aggravated with the threat or use of force on a person. Some people talk about how it's essentially robbery and battery or assault combined, if you like. This is an indictable offence, which means it's triable only in the Crown Court, and the maximum sentence that you could receive for an offence of robbery could be up to life, so discretionary life sentences are available, particularly reserved for those more serious offences like armed robbery. The Sentencing Guidelines Council provides more detail about the sentences, but for the purposes of your A-level law, you do not need to advise defendants on sentencing, only liability. So we're going to have a look at the definition. So I've written it in full here. So under section 8, a person is guilty of robbery if he steals immediately before or at the time of doing so he uses force on any person or puts or seeks to put any person in fear of being subjected to unlawful force. So I've put in bold the key words really here: steals and force, so the use or threatening of force. So essentially we have to make out the required elements for somebody stealing, but also the use or threatening of force. Now, if we break this definition down into elements, we have the stealing. So essentially here we're going to be looking at whether somebody has committed theft. And then we have an immediately before or at the time of doing so. So we have to look at what's required here in terms of the timing of committing these elements. The using of force or seeking to put any person in fear of being subjected to force. So essentially that's the use or threatening of force. So at the time you're stealing, or before, immediately before, so as close to the theft as possible, if you use force or threaten force, you could be guilty of robbery instead of theft. Okay, so let's have a look at the actus reus of this offence then. So because we have the stealing, the actus reus is, or part of the actus reus is the same as theft. So try to remember what the actus reus of theft is. And it's the appropriation of property belonging to another. But of course the additional actus reus to make this a robbery will be the act of using or threatening force immediately before or at the time of committing the offence. So let's have a look at the actus reus in a bit more detail. So exactly the same rules apply to the actus reus as they do to the actus reus of theft. So we have to have the appropriation of property belonging to another. So in terms of appropriation, only one right of an owner needs to be assumed at the time of appropriating the property. And of course, in relation to the mens rea, you only have to have intended to permanently deprive somebody of the property. You don't have to have made off with the property. You simply have to have done something which has assumed the right of the owner, but also evidences the intention to permanently deprive. And a really good illustration of this is the case of Corcoran and Anderton from 1980. Now this is a case involving 2 defendants, so Crown against Corcoran and Anderton, and 2 defendants working together, which you often see in criminal offences. You can have more than one defendant charged with an offence. So in this case, one of the defendants hit the victim across the back, whilst the other was working to take her handbag, so pulling at a handbag. The victim screamed as the handbag fell to the ground, and both defendants ran off empty-handed. So let's just have a look here. So do we have stealing? Do we have a theft? What is the appropriation? So here it would be pulling at the handbag. The particular defendant here, obviously working together, is assuming the rights of the owner by pulling at the owner's handbag. The handbag is property, hopefully you agree, and belongs to another. Objectively, are the defendant's actions going to be viewed as dishonest? Hopefully we can all agree yes. Is there intention to permanently deprive the owner of the property? Yes, they're trying to pull at a handbag evidentially to make off with it. So we have the theft made out. At the time or immediately before, is there use or threatening of force? So we can see here from the facts that at the time of the theft, we have the other defendant hitting the victim across the back. So the timing coincides, and we have use of force. Not just threatening of force, but use of force. So here we would have a robbery made out. How you break down the elements when you're looking at a particular case. Take it step by step, and my advice would be to start with the theft and then identify whether the force or the threat of force has been made out as well, and just make sure the timings coincide, which we'll go into detail with a little bit in a minute. So what do we mean by force or threatening of force? Very similar rules here to battery, really, in terms of, remember, battery is about the application of force. So same rules, force doesn't need to be applied directly to the victim. It can actually be applied to the property. And as we've just seen in Corcoran and Anderton, pulling at a handbag isn't necessarily going to be direct force applied to the victim. So that is absolutely fine. Force can be slight, doesn't require any violence. And again, we learned this principle when we looked at battery. And I believe that you learned the case of Collins and Wilcock for that. So the same principle is applied, but I have some robbery cases here for you to look at. And also in your own time, have a look at this YouTube clip. It's from the riots in 2011 and shows a young man being subjected to theft out of his rucksack. And there's just a particular point whilst the theft is occurring where it looks like it could turn into a robbery. And I just wonder what your thoughts would be on that, whether you think there's enough there to charge a robbery rather than a theft. So the relevant cases here that we could use, the case of Cloudon, where a shopping bag was wrenched from the victim's hand. This would illustrate force being applied to property rather than the victim directly, rather than a punch to the victim or a push. And then we have a case involving two co-defendants, Dawson and James, where, again, two defendants working together to steal from a victim, the victim being nudged in the back so that they lost their balance whilst another defendant took their wallet. So here we have very slight force, but we know that can still legally constitute force. It could be a robbery, and actually in this case it was. And these facts are very similar to the YouTube clip, which is why I just wanted you to watch and let me know what your thoughts are on that. So force can be slight, doesn't need to be as serious as a punch or particular weight behind it, and also it can be applied directly or indirectly. So we've got the same rules there. Try to use citation of the robbery cases rather than the battery cases in a robbery scenario. Okay, so we've covered the actus reus of theft, the force or threatening of force, and now we look at immediacy. So how immediate does the threat of force or use of force have to be, and does it have to occur at the same time as the theft? Practically, it might be unclear whether theft and use or threatening of force have occurred at the same time. And there are a couple of cases that have tried to identify or clarify whether this be the case. So in the case of Hale, we had two defendants who forced their way into a victim's house. One defendant went upstairs to commit the theft, so steal jewellery. The other defendant was downstairs using force to tie up the victim. It was unclear actually whether both of these actions occurred at exactly the same time. So you think, well, how does a court enable defendants to be convicted of robbery if, according to the legislation, we arguably don't have a coincidence of the elements here? And in this case, obviously one of the defendants here appealed, but the conviction of robbery was upheld. This is because although the court couldn't say whether the theft and the use of force occurred at exactly the same time, they decided that the theft was continuing. The assumption of the rights of the owner was continuing for as long as the defendant was in the property stealing the jewellery. So if you like, that's a bit of a kind of extension to what we deem appropriation to mean. This decision does potentially conflict with other cases on the point of how long an appropriation can continue for, but certainly a policy decision seems to be made here where if you have two defendants working together, then of course there should be some coinciding of the elements to bring the final charge together. And let's just have a look at another really important case that might actually clarify this for you a bit more. This was a case of Lockley in 1995. So Lockley stole cans of beer from an off licence. Now, of course, as soon as they pick up those cans of beer, they are appropriating, aren't they? But we know from Gomez that all elements of theft have to be satisfied for somebody to be charged. So essentially what we had is taking cans of beer, and as Lockley is trying to leave the shop, he ended up assaulting a shopkeeper who tried to stop him. So do we have a theft or do we have a robbery? If we apply the principle from Hale, where the appropriation is continuing, then arguably the theft is continuing as Lockley was leaving the shop. And what we've got there is where he assaults the shopkeeper, we have the use of force in order to steal. The stealing occurring at the time. So we have a widening of the meaning of appropriation even further in the area of robbery to cover instances like this and to find defendants guilty where it's actually unclear of the timing. So just bear that principle in mind because examiners love to test on things like this. Okay, the mens rea. So thinking about in terms of the theft part, we're going to have the same mens rea. You have to have acted dishonestly. So we use the Ivy test, looking at the standards of the objective, ordinary and decent people. Would the defendant's actions be viewed as dishonest? Use your judgment there. Do you think that the defendant is acting dishonestly? If you saw this incident happen in a shop or in a street, or you heard about it, would you think that's dishonest? And of course, having the intention to permanently deprive. So exactly the same rules as theft here to be applied. And in relation to the point of dishonesty, the exceptions under Section 2 also apply. So a defendant could argue their way out of a robbery conviction based on them not being dishonest. And have a look at this case, really good illustration. Robinson from 1977. So Robinson was owed £7. I mean, obviously that would be worth a lot more in the 70s than now, by the victim. He used a knife to threaten the victim and took £5 as part payment. He argued he wasn't dishonest. And I just wonder whether you can remember which exception applied. So make sure you pause and have a look at that, please. And I'm pleased to tell you the exception of believing you have the right to deprive under Section 21A of the Theft Act would be the relevant section here. So make sure that you do use the full rules when you're going through the theft part of robbery. And of course, to make this a full robbery offence, you have to have had the intention or be reckless as to the application or the threatening of unlawful force. So the same rules apply for making out intention. Was it the defendant's main aim or purpose to apply or threaten unlawful force? Or were they reckless? Did they realise there was a risk through their actions that they would apply or threaten unlawful force? We make out a case for those. Commonly, students miss this part out, so just remember that there is mens rea, not just for theft, but also for robbery too. Robbery is a really popular examinable area. As you see here, it's come up pretty much every year, so plenty of questions for you to practice, and I'm just going to take you through some little practice scenarios now, because really that is how big the area of robbery is, very small. You have a scenario here which is a 25 mark scenario. Advise whether Richard and Steve are guilty of robbery and burglary, including any defences they may raise. So remember, defences can counter liability. What we're going to do after we finish property offences is go on to some final general defences. So there may be one or two in here that you identify, but we haven't learnt the law for yet. So don't worry too much about that. So if I draw your attention to the first part, so Richard uses a lot of drugs and he owes money to his dealer. Richard and his friend Steve start stealing from tourists. This is the important part. They approach Kenji, who has a large camera hanging from a shoulder strap. Richard puts his fingers in his pocket to look like a gun, and Steve pulls the camera. Kenji tries to hold on, but Steve knocks him to the ground and runs off with the camera. Hopefully what you've identified here, or what you're thinking about, is a potential robbery. And of course the rest of the scenario will be relevant to the burglary. So you separate your answer out into two paragraphs, one for the robbery and one for the burglary. So if we're going to make out the robbery, we need to make out we obviously start by saying Richard and Steve could be guilty of robbery under Section 8 of the Theft Act 1968. Which is, and then you can just briefly define it. So we start by making out the theft. So do they appropriate property belonging to another dishonestly and with the intention to permanently deprive? So the appropriation, you could argue, occurs when Steve pulls the camera. The camera is property. It clearly belongs to Kenji, the tourist. Are they being dishonest? Well, they want to, they need money because Richard owes money to his dealer. So clearly there is some element of dishonesty there. They want to steal money. They're taking money from tourists, and Kenji in particular. So objectively, this would be seen as dishonest conduct. Do they have intention to permanently deprive? Again, they need money, they have been stealing from tourists, and they are trying to take the camera from Kenji. Of course, we have the evidence of Steve running off with the camera, so this is the best evidence of intention to permanently deprive. And of course, when he later sells it on, there is no intention to give that property back. So clear evidence of a theft here. Do we have use or threatening of force? So we have kind of two parts here that would satisfy this. We have the first with Richard putting his fingers in his pocket to look like a gun. And if you think back to the case of Bentham we looked at when we were learning our lawmaking unit, this certainly would be an action that causes a victim to fear. This is certainly going to be threatening of force. And of course, Bentham was guilty of attempted robbery in addition to other things. So certainly that would be enough to threaten force. But we also have the added use of force where Steve knocks Kenji to the ground. So we have clear, direct application of force here. We then, as a final element, need to decide whether it's immediately before or at the time. And I think you could argue, and we could all agree, that these elements are coinciding. And does or do Steve and Richard have the intention to apply unlawful force or to threaten? I think by nature of their actions, we could say there is intent there. We're not looking at reckless actions. We're looking at clear purpose here and a decision to steal from Kenji. And of course, by putting your fingers in your pocket to look like a gun, clearly that's not a reckless act. That's a decision to try to cause Kenji to fear here. So we would have robbery made out. So please do have a go at writing that answer. And of course, you've got the other part for burglary that you can practice too. And hopefully you see with the burglary part, this is very similar to a key case that we looked at in that tutorial. There's additional exam scenario here from 2013, and I've just highlighted some of the key parts here. So please do have a look at that one. So there is a potential defence here that we will come back to at a later stage, a potential defence that could be raised. And I've just given you some notes here on how you would answer the scenario. So as I said before, my advice is to state and apply the theft, then identify the force or the threatening of force, the fact that it should be immediately before or at the time, and then of course make sure you've got the mens rea in there as well. So make yourself a little plan for applying the law and make sure you don't miss anything out. Easy marks to gain. So please take your time reading through these slides. Please don't just stick to the time and listen to me. Take a moment to pause, read the slide and make notes and make sure you understand it. If you have any questions, you can always comment on this video too. So what I've put in this slide is the latest practice question, which covers both robbery and burglary. And what I'll send you to look at for next week is potential exemplar answers for this scenario. As an examiner, I marked hundreds of these, so I know this scenario really well. It's a really good one to practice on. Covers obviously both robbery and burglary, and that's what you could expect to receive. You could receive a theft scenario, you could receive a robbery and burglary scenario, you could receive combinations of the three. And of course, 2019, the OCR paper featured heavily application-wise on theft, robbery and burglary. So it may be less likely to, but I'm hopeful that we're going to receive the paper for this year so that we can have a look at it together. So in summary, what have we covered across the three tutorials? We've covered the law of theft, we've covered application, we've covered evaluation points for potential theft essays, which are more common than the other two, I have to say. We've looked at the law of burglary, covered application and evaluation, and we've just covered the law of robbery, and I've just briefly taken you through some application practices. An essay is unlikely because it's so small. So for consolidation, make sure you have summary paragraphs for each of the property offences. You have one for burglary, you do have one for theft as well, but make sure that you speak to me if you're unsure of anything. And what we're going to go on to next week are general defences. So we're nearing the end of criminal law, and I hope you've enjoyed this. Thank you very much.